on behalf of the state.
Kim Blandino appearing pro se for Kim Blandino with standby counsel Ben.
Yes, good morning, Your Honor. Ben Bateman, Bar number 933. I have been appointed as
He's
standby counsel.
elbow counsel. I have some administrative and procedural matters before we even get to anything.
Well, hold on, this is status check counsel.
My understanding is that Mr. Blandino has not yet been evaluated, and so the court's going to need to continue this out for him to be evaluated. As a result, we're going to need to vacate the current trial date, let's say.
Mr. Blandino, have you been evaluated?
By who? My friends and family evaluate me as perfectly sound and knowing quite a bit about the law.
Okay, so you haven't been evaluated by a doctor yet?
I've been to this Hope clinic where they're a medical doctor, but not. Are you meaning psychologists or psychiatrists?
Counsel?
I just want to be specific for the record.
Yeah, so we would just need him to be evaluated by two psychiatrists or psychologists pursuant to the court's order to have him evaluated here in the competency court. As a result, it's going to necessitate us vacating that trial date.
Is there any objection to vacating the trial date and setting a new date?
I have some administrative and procedural matters. I don't want the court to just gloss over those. I have a right to
We're
read the
gonna
record.
get to those in a minute,
Okay.
okay? But first I wanna deal with this issue. This is why it's on calendar today,
Yes,
so let's
I have
deal
an
with it.
objection to this entire competency proceedings. This is
Okay,
merely
so we're gonna,
vindictive on part of the DA's office.
all right, everybody take a deep breath. All right, now, do you have any objection to vacating the trial date to continuing that?
If you want to continue to another date, you're not the normal judge, I understand, on this case anyway, so I don't have an objection to that continuance. I just have objection generally to the going through competency proceedings. I don't
Standby
waive the
counsel,
right.
do you have any objection to vacating the trial date and setting a new date?
Well, I do not. I think, obviously, it's been ordered, so, but, court's indulgence.
Oh, no, I understand that. Well, I just want for the record to be known clearly, Judge, that I haven't waived my speedy trial right. I was willing to waive the time that the DA objected to. However, they were the ones that asked for the stay in the other court, Michelle Levitt's court, to go through these competency proceedings, which is merely vindictive on the DA's part. So therefore, I don't have any general objection to continuing it. I mean, I think that's fine. You're not, is it Linda Bell was supposed to be here on this date? I understand you're subbing in. So one of the administrative and procedural matters that I wanted to address was the fact if there's a written request pursuant to District Court Rule 18 that requires, or that allows you to sit in for Judge Bell, because this is a court rule that's required to be complied with. Do you have such a written request from the judge that he's sitting in on this matter?
Mr. Blandino, I was assigned to substitute in today for the chief judge at her specific request.
Was it a written request? The rule requires a written request. I've got copies of it if you'd like to see.
All right.
Of the rule.
So do you object to me presiding over this case today? Is that what I'm hearing?
Well, I have a general thing that I'm not able to present. This court needs to take judicial notice. There's a vexatious litigant order against me. Now, while that's on appeal, only the chief judge or the chief judge's designee can allow me to file any written motions. That's why you haven't seen any opposition to the competency proceedings, except for, this is one of the administrative matters that I wanted to bring up. I sent, Your Honor, an email copied to the district attorney, both Dickerson, Marlin, and to Judge Bell, and to Judge Levitt. And so I said that, hey, look, a number of different issues that I've got no other way to do this. It wasn't ex parte communication. Apparently your JEA indicated that that is ex parte, but if I'm serving the other party with a copy, I don't see how it could possibly be. But even so, Rule 2.9, which I adequately copied and sent by way of email, shows clearly that if there is ex parte communication, either inadvertent or otherwise, as long as the opposition has an opportunity to respond to said communication, you're perfectly well within the Rule 2.9. Now, since I can't file any written motions without the chief judge designees, because Judge Bell actually has an unadjudicated motion to disqualify against her. But my position is, and always has been, that this case needs to be assigned to a judge outside of this district. I'm gonna have to call multiple judges in this case. I've been accused of impersonating a public officer, so I'll have to call as witnesses, subpoena with evidence and testimony, and written documentation, members of the Nevada Commission on Judicial Discipline. I've been accused of extorting the temporary judge, and in that regard, it's absolutely imperative to show that I've been doing this for years, so I'm gonna have to call Judges Herndon, Judges Baer, ex-Judge Maupin, ex-Justice Maupin now, all these different things to show that I have in good faith been investigating judges for corruption and for misconduct for many years now. And I didn't even realize that for many decades, I've been brought to the point to which I've been brought here now. And that is having all this information, all this legal knowledge, and knowing procedures, I've been put to this position to make these claims. And so the DA wants to do a drive-by conviction of felony, and Kim's counsel, which is me, is not going to allow that. Kim has to represent his client, which is me, zealously and vigorously, and will do so to the best of his ability. I'm doing this full time. I'm doing basically nothing but eating, sleeping, and doing legal work. Aside from the normal chores that you have to do, make your bed and things, but that's all I'm doing. And so, if they want to do some kind of drive-by trial and vindictively put me through these competency proceedings, I am going to object to that. And I'm going to object generally to any district court judge hearing this. I've got a prima facie case. Manning versus State was just decided just recently. It's coming back down on vindictive prosecution. When a prima facie case is made for vindictive prosecution, there has to be an evidentiary hearing for that. Now, this latest scheme by the district attorney to put me through competency proceedings based on my filings before the Nevada Supreme Court clearly show additional vindictiveness based on my religious beliefs and my right to exercise my religious beliefs and my right to seek redress from an appellate court. They're saying, okay, Kim, we'll turn the screws to you just a little bit harder now and put you through competency proceedings. And maybe, just maybe, we can find some psychologist that's off his meds or something and will find you incompetent and relieve us of the necessary prosecution, and then they can lock you up in Lakes Crossing for some time. Well, Kim cannot allow that to happen, as good counsel that he is, if the defendant could speak for just a minute, as I just did. But I have a general objection to that. Because of the vindictiveness of prosecution, they really should recuse themselves. They know it's vindictive. I just got discovery yesterday, after they, in open court, said on their honor they would have it in the Justice Court. Now all of this information, it appears, they had as of May 30th of this year, and now they're just delivering it. They violated the 5-day promise within the preliminary hearing. Now granted, they went to a grand jury indictment. That doesn't negate the vindictiveness of this, though. Huh? It's a long machine.
Counsel, any objection to me hearing this matter? State.
No, Your Honor.
All right, what I'm gonna do is vacate the trial date, set it for status check and competency court. Thank you, Mr. Blandino.
What day is that?
10 a.m.
I'm sorry?
November 1st at 10 a.m.
November 1st, and then which court is that going to be?
Right here.
So in 10C, or is it going to be in Judge Bell's court?
You know, I don't know.
And Your Honor, we'll issue a written order on that. That's just want to confirm that all proceedings are being suspended pursuant to NRS 178.405.
Correct, Counsel.
Thank you.
There's one other administrative matter, and this is important to get on the record. I had issued an objection to Mr. Ben Bateman being a standby counsel, and that was in Levitt's courtroom, because I hadn't interviewed him, didn't know if there was any conflict. I want to, for the record, say that I approve of Mr. Bateman as my standby counsel. I withdraw the objection that was entered the last time in Judge.
Noted. Thank you, Mr. Bateman. Have a wonderful day. Next.
Thanks, Judge.